Hello and welcome to Bar 10, where it's our goal to help you pass the bar exam 10 questions at a time. This is lesson 13. Please hit the like button, subscribe, and click the notifications bell so you can be updated every time we upload new content, which is usually about 8 a.m. Eastern Standard Time every single day of the year. Okay, let's get started with question number 1. Olive owned Blackacre, a single-family residence. 15 years ago, Olive conveyed a life estate in Blackacre to Lois. 14 years ago, Lois, who had taken possession of Blackacre, leased Blackacre to Trent for a term of 15 years at the monthly rental of $500. 11 years ago, Lois died intestate, leaving Ron as her sole heir. Trent regularly paid rent to Lois and, after Lois's death, to Ron until last month. The period in which to acquire title by adverse possession in the jurisdiction is 10 years. In an appropriate action, Trent, Olive, and Ron each have asserted ownership of Blackacre. The court should hold that title in fee simple is A. in Olive because Olive held a reversion and Lois had died. B. in Ron because Lois asserted a claim adverse to Olive when Lois executed a lease to Trent. C. in Ron because Trent's occupation was attributable to Ron and Lois died 11 years ago. Or D. in Trent because of Trent's physical occupancy and because Trent's term ended with Lois's death. Please choose the best option. The correct answer here would be C, in Ron, because Trent's occupation was attributable to Ron and Lois died 11 years ago. A life estate is lifetime ownership of land. Upon the expiration of a life estate, the interest in the property reverts to the grantor unless it's assigned to a third party. Adverse possession allows a person to obtain title to land that they've taken possession of for the statutory prescribed period of time, here 10 years under the statute. In order for possession to ripen into title by adverse possession, the following conditions must be satisfied. 1. Actual possession. 2. Exclusive possession. 3. Continuous possession. 4. Open and notorious possession. 5. Hostile possession. And 6. The running of the statutory time frame. The idea of tacking allows a claimant to tack on her time in adverse possession with a predecessor adverse possessory time if there is any privity between the two adverse possessors. In this case, Olive conveyed a life estate in Blackacre to Lois. Lois then subsequently leased Blackacre to Trent for a term of 15 years at the monthly rent of $500. When Lois died intestate 11 years ago, the title to Blackacre reverted back to Olive. As such, Trent's possession of Blackacre was hostile. There is privity between Ron and Trent, i.e. there's a landlord-tenant relationship, so Ron would be able to tack Trent's possession of Blackacre to run the required statute. Since Lois died 11 years ago, and the period in which to acquire title by adverse possession in the jurisdiction is 10 years, the court should hold that title in fee simple is in Ron. Let's move on to question number 2. Patron ate a spicy dinner at restaurant on Sunday night. He enjoyed the food and noticed nothing unusual about the dinner. Later that evening, Patron had an upset stomach. He slept well through the night, went to work the next day, and ate 3 regular meals. His stomach discomfort persisted, and by Tuesday morning, he was too ill to go to work. Eventually, Patron consulted his doctor, who found that Patron was infected with a bacterium that can be caused from contaminated food. Food can be contaminated when those who prepare it do not adequately wash their hands. Patron sued restaurant for damages. He introduced testimony from a health department official that various health code violations had been found at restaurant both before and after Patron's dinner, but that none of restaurant's employees had signs of bacterial infection when they were tested 1 month after the incident. Restaurant's best argument in response to Patron's suit would be that A. No one else who ate at the restaurant on Sunday complained about stomach discomfort. B. Restaurant instructs its employees to wash their hands carefully and is not responsible if any employee fails to follow these instructions. C. Patron has failed to establish that restaurant food caused his illness. Or D. Patron assumed the risk of an upset stomach by choosing to eat spicy food. Take 10 seconds and choose the best option. If you chose option C, you'd be correct. Patron has failed to establish that restaurant's food caused his illness. To establish a prima facie case of negligence, the plaintiff must prove 1. A duty, 2. A breach of that duty, 3. Causation, and 4. Damages. Causation is the link between the injury to the plaintiff and the defendant's breach of the duty of care. Actual cause exists if the plaintiff would not have been injured but for the breach of the duty by the defendant. Here, restaurant's best argument among the answer options is causation. Patron is unable to prove that restaurant's employees had signs of bacterial infection at the time patron ate the spicy dinner. In fact, none of the restaurant's employees had signs of bacterial infection when they were tested 1 month after the incident. Patron has not shown that patron would not have been infected with the bacterium but for restaurant's contaminated food. Thus, restaurant's best argument in response to patron's suit would be that patron has failed to establish that restaurant's food caused his illness. Let's move on to question number 3. At 11 p.m., John and Marcia were accosted in the entrance to their apartment building by Dirk, who was armed as well as masked. Dirk ordered the couple to take him into their apartment. After they entered the apartment, Dirk forced Marcia to bind and gag her husband, John, and to open a safe which contained a diamond necklace. Dirk then tied her up and fled with the necklace. He was apprehended by apartment building security guards. Before the guards could return to the apartment, but after Dirk was arrested, John, straining to free himself, suffered a massive heart attack and died. Dirk is guilty of A. Burglary, robbery, and murder. B. Robbery and murder only. C. Burglary and robbery only. D. Robbery only. Take 10 seconds and choose the best option now. If you chose option A, you'd be correct. Burglary, robbery, and murder. Under the felony murder rule, a person can be found guilty of a killing that occurs during the commission of an underlying felony that is inherently dangerous, such as burglary, arson, rape, robbery, or kidnapping. Remember BARK, B-A-R-R-K. Burglary, arson, rape, robbery, kidnapping. Robbery is the wrongful taking and carrying away of another's tangible personal property from another's person or presence by force or threat of immediate harm. At common law, burglary is the trespassory breaking and entering of a dwelling at night time with the specific intent to commit a felony or larceny therein. In this case, Dirk is clearly guilty of larceny and robbery by ordering John and Marcia to take him into their apartment at 11 p.m. at night with the intent to commit a robbery. Dirk has satisfied all of the elements of burglary by removing the diamond necklace and John and Marcia's presence by threat of force. Dirk has also satisfied all of the elements of robbery. Lastly, both robbery and burglary are inherently dangerous to human life, so if John's death occurred during the commission of these felonies, Dirk would also be guilty of murder under the felony murder rule. Here, Dirk is guilty of felony murder because John's death did occur during the commission of Dirk's inherently dangerous felonies. The fact that John died after Dirk was arrested does not change this fact. John died while struggling to free himself after being bound and gagged by Marcia at Dirk's direction. Since John's death was clearly a reasonably foreseeable result of these inherently dangerous felonies, Dirk is guilty of murder as well. As a result, A, burglary, robbery, and murder is the best option. Let's look at question number 4 now. Gourmet, a famous chef, entered into a written agreement with his friend Delagore, a well-known interior decorator respected for his unique perspectives and designs, in which Delagore agreed for a fixed fee to design the interior of Gourmet's new restaurant, and upon Gourmet's approval of the design plan, to decorate and furnish the restaurant accordingly. The agreement was silent as to assignment or delegation by either party. Before beginning the work, Delagore sold his decorating business to Newman under an agreement in which Delagore assigned to Newman, and Newman agreed to complete the Gourmet Delagore contract. Newman, also an experienced decorator of excellent repute, advised Gourmet of the assignment and supplied him with information confirming both Newman's financial responsibility and past commercial success. Is Gourmet obligated to permit Newman to perform the Gourmet Delagore agreement? A. Yes, because the agreement contained no prohibition against assignment or delegation. B. Yes, because Gourmet received adequate assurances of Newman's ability to complete the job. C. No, because Delagore's duties were of a personal nature involving his reputation, taste, and skill. D. No, because Delagore purported delegation to Newman of his obligations to Gourmet affected a novation. Take 10 seconds and choose the best option. If you chose option C, no, because Delagore's duties were of a personal nature involving his reputation, taste, and skill, you'd be correct. A delegation exists when one party to a contract transfers the duty to perform under the contract to a third party. If the contract calls for special skills or reputation of the delegator, then performance under this contract cannot be delegated to a third party, even if that third party has equal or greater skill. Here, Delagore is a well-known interior decorator, respected for his unique designs. Delagore's special skills of a personal nature cannot be delegated to Newman, even though Newman is also an experienced decorator of excellent repute with past commercial success. Think of this very similarly in our industry. If a person hires a defense attorney, they choose that defense attorney because of that defense attorney's reputation, because of that rapport with that particular defense attorney. That defense attorney cannot necessarily just, in essence, assign that contract to another individual without the consent of the client. Otherwise, there would be a little bit of a problem long-term with contracts of this personal service nature. Question number 5. The legislature of State X enacts a statute that it believes reconciles the state's interest in the preservation of human life with a woman's right to reproductive choice. That statute permits a woman to have an abortion on demand during the first trimester of pregnancy, but prohibits a woman from having an abortion after that time, unless her physician determines that the abortion is necessary to protect the woman's life or health. If challenged on constitutional grounds in an appropriate court, this statute will probably be held A. Constitutional, because the state has made a rational policy choice that creates an equitable balance between the compelling state interest in protecting fetal life and the fundamental right of a woman to reproductive choice. B. Constitutional, because recent rulings in the United States Supreme Court indicate that after the first trimester, a fetus may be characterized as a person whose right to life is protected by the Due Process Clause of the 14th Amendment. C. Unconstitutional, because the state has, without adequate justification, placed an undue burden on the fundamental right of a woman to reproductive choice prior to fetal viability. Or D. Unconstitutional, because the statute, unqualifiedly permitting abortion at one stage of pregnancy and denying it at another, with only minor exceptions, establishes an arbitrary classification in violation of the Equal Protection Clause of the 14th Amendment. Take 10 seconds and choose the best answer. If you chose option C, you'd be correct. This would be unconstitutional because the state has, without adequate justification, placed an undue burden on the fundamental right of a woman to reproductive choice prior to fetal viability. A woman has the right to choose whether to have an abortion prior to fetal viability and to obtain one without undue interference from the state. The rule is that prior to viability, usually late second semester, states may not prohibit abortions, but a state may regulate so long as the regulation does not create an undue burden on one's ability to get an abortion. In this case, the statute of State X prohibits a woman from having an abortion after the first trimester, unless her physician determines that the abortion is necessary to protect the woman's health or life. However, during pre-viability, a state may not enact measures that would impose an undue burden on one's ability to get an abortion. As a result, you'd argue that the limitation is without question an undue burden. So it should be found unconstitutional. Option C would be the best answer as a result. Okay, let's move on to question number 6. Defendant is charged with murder in connection with a carjacking incident during which defendant allegedly shot victim while attempting to steal victim's car. The prosecutor calls victim's 4-year-old son, whose face was horribly disfigured by the same bullet, to testify the defendant shot his father and him. The son's testimony should be A, admitted, provided the prosecutor first provides evidence that persuades the judge that the son is competent to testify despite his tender age. B, admitted, provided there is sufficient basis for believing that the son has personal knowledge and understands his obligation to testify truthfully. C, excluded because it is insufficiently probative in view of the son's tender age. Or D, excluded because it is more unfairly prejudicial than it is probative. Take 10 seconds, and choose the best answer. The best answer would be B, admitted, provided there is sufficient basis for believing that the son has personal knowledge and understands his obligation to testify truthfully. Under the federal rules of evidence, every person, regardless of age, is competent to be a witness. Competency under the federal rules of evidence requires that a person have personal knowledge of a matter and understand the obligation to testify. As a result, B would be the only option of the four choices that specifically meets the exact needs of the federal rules of evidence. So B would be the best answer. Okay, question number 7. When parents were told that their child's son should repeat second grade, they sought to have him evaluated by a psychologist. The psychologist, who charged $300, determined that son had a learning disability. Based upon the report, the school board placed son in special classes. At an open meeting of the school board, parents asked that the $300 they had paid to the psychologist be reimbursed by the school district. A reporter attending the meeting wrote a newspaper article about this request, mentioning son by name. In a privacy action brought by the son's legal representative against the newspaper, the plaintiff will A, recover because the story is not newsworthy, B, recover because son is under the age of consent, C, not recover if the story is a fair and accurate report of what transpired at the meeting, or D, not recover if parents knew that the reporter was present. Take 10 seconds, choose the best answer. The correct answer would be C, not recover if the story is a fair and accurate report of what transpired at the meeting. The tort of false light, slander, anything along those lines requires that the defendant be placed in public in a false light that would be highly offensive to a reasonable person. Generally, truth of the matter is an absolute defense. As a result, the option C, which states that the child's attorney would not recover if the story is a fair and accurate report of what transpired at the meeting, would be in fact accurate. Furthermore, in this case, the reporter attended an open meeting of the school board and wrote a newspaper article about what transpired at this meeting, specifically that parents asked to be reimbursed. As such, as long as the report story is fair and accurate, and it is a report of what actually in fact transpired at the school board meeting, the plaintiff will not be able to recover. Question number 8. Grace, while babysitting one night, noticed that Sam, who lived next door, had left his house, but that the door did not close completely behind. Grace said to Roy, the 11-year-old boy she was babysitting with, "Let's play a game. You go next door and see if you can find my portable television set, which I lent to Sam, and bring it over here." Grace knew that Sam had a portable television set, and Grace planned to keep the set for herself. Roy thought the set belonged to Grace. Went next door, found the television set, carried it out the front door. At that moment, Sam returned home and discovered Roy in his front yard with the television set. Roy explained the game he and Grace were playing. Sam took back his television set and called the police. Grace is A, not guilty of larceny or attempted larceny because Roy did not commit any crime. B, not guilty of larceny but guilty of attempted larceny because she never acquired possession of the television set. C, guilty of larceny as an accessory to Roy. D, guilty of larceny by the use of an innocent agent. Take 10 seconds and choose the best option now. Option D would be the best choice. Guilty of larceny by the use of an innocent agent. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. In this case, Grace was the principal and Roy was Grace's innocent agent. Grace had the intent to permanently deprive Sam of the television set by wrongfully taking and carrying away Sam's portable television set. Grace tricked Roy into thinking the television set was hers, so Roy did not have the requisite intent to be guilty of larceny. Accordingly, Grace is guilty of larceny by the use of an innocent agent. Let's analyze option A, not guilty of larceny or attempted larceny because Roy did not commit any crime. The flaw with this argument would be that any time a criminal utilizes an intermediary innocent agent, they would be completely absolved of liability. This is not something that could be reasonable or permitted within the court of law. B, not guilty of larceny but guilty of attempted larceny because she never acquired possession of the television set. Larceny does not require Grace to have acquired possession of the television set, only that she have removed it or that it be moved from the location where it initially sat. As a result, once the child lifted the television set and moved it, regardless of it coming into Grace's possession or not, the larceny had been completed. And now we're looking at option C, guilty of larceny as an accessory to Roy. The problem with the logic here is that in order for her to be guilty as an accessory to Roy, Roy would ultimately have to be guilty as well. And given this fact pattern, it's clear that Roy was an innocent agent and acting without the proper mens rea for the crime in question. As a result, option D is the best choice. Question number 9. Gourmet, a famous chef, entered into a written agreement with his friend Delagore, a well-known interior decorator respected for his unique designs, in which Delagore agreed for a fixed price to design the interior of Gourmet's new restaurant, and upon Gourmet's approval of the design plan to decorate and furnish the restaurant accordingly. The agreement was silent as to assignment or delegation by either party. Before beginning the work, Delagore sold his decorating business to Newman under an agreement in which Delagore assigned to Newman, and Newman agreed to complete the Gourmet-Delagore contract. Newman, also an experienced decorator of excellent repute, advised Gourmet of the assignment and supplied him with information confirming both Newman's financial responsibility and past commercial success. If Gourmet allows Newman to perform and approves his design plan, but Newman fails without legal excuse to complete the decorating as agreed, against whom does Gourmet have an enforceable claim for breach of contract? A, Delagore only, because Delagore's agreement with Newman did not discharge his duty to Gourmet, and Newman made no express promise to Gourmet. B, Newman only, because Delagore's duty to Gourmet was discharged when Delagore obtained a skilled decorator, i.e. Newman, to perform the Gourmet-Delagore contract. C, Newman only, because Gourmet was an intended beneficiary of the Delagore-Newman agreement, and Delagore's duty to Gourmet was discharged when Gourmet permitted Newman to do the work and approved Newman's design. D, either Delagore, because his agreement with Newman did not discharge his duty to Gourmet, or Newman, because Gourmet was an intended beneficiary of the Delagore-Newman agreement. Take 10 seconds. Choose the best option now. If you chose option D, either Delagore because of his agreement with Newman, or Newman because Gourmet was an intended beneficiary of the Delagore-Newman agreement, you would be correct. A delegation exists when one party to a contract transfers a duty to perform under the contract to a third party. A delegator is the party who transfers the obligation to perform. A delegatee is the third party who agrees to perform under the contract in place of the delegator, and an obligee is the other party to the contract. The delegator is always liable to the obligee if the delegatee fails to perform. Alternatively, if there was consideration for the delegation, the obligee could choose to sue the delegatee for failure to perform, since the obligee is a third-party beneficiary to the delegator-delegatee contract. Here, Delagore is the delegator, Newman is the delegatee, and Gourmet is the obligee. If Gourmet allows Newman to perform, Delagore would remain liable to Gourmet if Newman failed to complete the decorating as agreed. Thus, Gourmet could sue Delagore for Newman's failure to perform. Alternatively, Gourmet could sue Newman for failing to perform, since Gourmet is a third-party beneficiary to the Delagore-Newman delegation contract, which was for consideration. Thus, as a result, Gourmet would have an enforceable claim for breach of contract either against Delagore or Newman. So D would be the best option. Question number 10, the final one in this grouping. The vaccination of children against childhood contagious diseases such as measles, diphtheria, and whooping cough has traditionally been a function of private doctors and local and state health departments. Because vaccination rates have declined in recent years, especially in urban areas, the President proposes to appoint a Presidential Advisory Commission on Vaccination, which would be charged with conducting a national publicity campaign to encourage vaccination as a public health measure. No federal statute authorizes or prohibits this action by the President. The activities of the Presidential Advisory Commission on Vaccination would be financed entirely from funds appropriated by Congress to the office of the President for such other purposes as the President may think appropriate. May the President constitutionally create such a commission for this purpose? A. Yes, because the President has plenary authority to provide for the health, safety, and welfare of the people of the United States. B. Yes, because this action is within the scope of executive authority vested in the President by the Constitution and no federal statute prohibits it. C. No, because the protection of children against common diseases by vaccination is a traditional state function, and therefore is reserved to the states by the 10th Amendment. No. Option D, no, because Congress has not specifically authorized the creation and support of such a new federal policy. Take 10 seconds, choose the best option. If you chose option B, you'd be correct. Yes, because the action is within the scope of the executive authority vested in the President by the Constitution and no federal statute prohibits it. Generally, the President's power is at its apex when he acts pursuant to power given to him by Congress. They are lessened if there is no congressional legislation on the matter, and they are at their lowest when he is acting in the face of congressional legislation. The Supreme Court has said that when the President acts in the face of congressional disapproval, he may only do so if the power he exercises is vested in him alone by the Constitution and denied to Congress. Where he acts in the face of congressional silence on a matter, the action will be approved if the act is within the power of the President. This would be a zone of twilight situation because the act is within the President's powers and Congress has been silent on the issue. As such, the President may constitutionally create such a commission for the purpose of conducting a national publicity campaign to encourage vaccination as a public health measure. As usual, thank you for listening to Bar 10's Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload daily at 8 a.m. Eastern Standard Time, so please like, subscribe, and click the notification bell so that you can be updated every time we upload new content.